Evan Bernick is standing by, and thank you, Mike, for the laugh. Evan Bernick is the assistant professor at NIU College of Law and a great resource for us as well. We always appreciate your time, Professor. Thanks for coming on.
Thanks for inviting me back. It's good to be back, Steve.
We have several really key decisions from the Supreme Court that are pending. Obviously, presidential immunity is maybe the biggest, though certainly you could argue the others are equal. What is your sense of where this immunity decision might fall, and when might we hear, he tried to say?
So it is unlikely that the Supreme Court is going to agree with the broadest claims that Trump's lawyers are making to the effect that a president cannot be prosecuted criminally after he leaves office for any act that he commits in his official capacity while in office. However, the court seems to be divided about whether certain criminal statutes that arguably apply to the president have to explicitly say that they apply to the president in order for the president to be prosecuted under them. So this has the makings of kind of a fractured decision that leaves some uncertainty about what the law is going forward, but does reject the very broad claims that the president is just above the law.
Is this, a couple of follow-ups here before we get to the others, is this in a sense, and I understand that the Supreme Court job, I suppose, is this, a real-time rewrite of the Constitution to fit the circumstances by some?
So that is certainly how the critics of the argument for absolute presidential immunity are framing it, that we have an effort by a president who encouraged an insurrection to try to rewrite the Constitution after the fact to insulate himself from the consequences. And to be fair to the critics of these arguments, the Constitution doesn't say anything about presidential immunity at all. It says things about immunity for legislators, and the inference that you would draw from the fact that it specifically says, hey, legislators are immune from what they do while they're going to and from the legislature, but it doesn't say anything about the president, is that there just is no presidential immunity. Also, the scope of these arguments, the idea that it would somehow affect the president's ability to conduct himself in office, to know that after he leaves office he could be potentially criminally prosecuted. Some justices seem to be skeptical of the idea that we need such a strong medicine to encourage the president to take bold, decisive, and legitimate actions while in office.
Professor, how rare is it, or has it happened more frequently than we would think, how rare is it for a SCOTUS justice to recuse himself or herself from a case? And I ask because Trump, of course, appointed Gorsuch, Kavanaugh, and Amy Coney Barrett. Would there ever be any sort of a personal recusal because they were appointed by the person who is before them?
No. The kind of cases in which we have seen recusal have involved some involvement in ongoing litigation, either in support of a law that's now being challenged, or in the case of Elena Kagan, because as a Solicitor General under Obama, she had some role in the Obamacare litigation, subsequently deciding not to sit on any Obamacare cases. But it is not surprising to me in the least that Justice Alito and Justice Thomas are deciding not to recuse here in cases where recusal has been called for based on their personal involvements and their spouse's ideological involvement in cases.
They're not taking up the double jeopardy question, right? Because it's an insane premise that a congressional action of impeachment is the same as a court prosecution in our justice system. They're completely different things.
No, and the whole point of specifically saying that impeachment is done by the Senate and that subsequently the person is subject to prosecution by law is to establish that impeachment is not a criminal trial. There is no double jeopardy argument that has any legitimacy, and you're right to call it insane.
All right. Abortion medication. It gets a little complex, but in troubled pregnancies, medication to create the end of the circumstance where this baby who is not viable And it ends up, being the end of the pregnancy. It's a very controversial thing. Lots of opinions on both sides. What are they going to do here?
They are likely to allow mifepristone to remain available, and that might seem surprising because we have a majority conservative court that has the decision in Dobbs indicating that we don't have a constitutional right to terminate a pregnancy suggests is not supportive of abortion access. What seems to be driving even the conservative justices to reject this challenge to the FDA's approval of mifepristone, which is part of a two-drug cocktail that's responsible for roughly more than half of abortions in America, is the connection between the supposed violation of the law by the FDA and any injury to any particular people. So you've got a bunch of doctors and medical organizations who are claiming that because it's possible that people could suffer complications from mifepristone and they could possibly have to treat them, and they're opposed to abortion, they've been injured. And what even the conservative justices seem to be thinking here is that's really, really attenuated, very speculative, because there aren't many complications from mifepristone, and there are all these protections in federal law that ensure that people opposed to abortion don't have to participate in. So even though you have justices, a majority of whom are opposed to abortion, I think that they are going to allow mifepristone to remain available, and the FDA's decision to approve mifepristone and expand access to it is going to stay in place.
Pending that approval, though, Professor, will that affect the recent Texas ruling and the Louisiana rulings on the abortion pill? So in other words, when that ruling happens, will the states then have to change that law to reflect the SCOTUS decision?
Yeah, so right now, Miffy is widely available because the order saying that it has to be unavailable was put on hold.
Okay.
As a matter of federal law, states obviously have to follow federal law. However, we are seeing efforts by states to criminalize various forms of reproductive health, but as a matter of federal law, if the federal government approves mifepristone and allows it to be on the market, states can't counteract that.
It is Professor Evan Bernick. There's also a big online disinformation case the Supreme Court is about to rule on as well. Misleading or dangerous information online, how much social media can be policed by the government, and what is the free speech implications of it. These decisions usually happen in early June by way of announcements. When should we expect them, or is it just too hard to say?
It's June. That's
June.
all I can say. It's sometime in June. That's when the court releases. Most Supreme Court decisions are unanimous, surprisingly enough, but all the non-unanimous, controversial ones happen in June, and this is likely to be one of them. The question of just when government pressure on social media companies or private companies more generally to do things regarding their speech crosses the line between what's referred to as jawboning and persuasion, which everybody thinks is okay, and coercion, which is not. The Supreme Court actually reached a decision very recently involving a First Amendment claim against New York in connection with efforts to pressure financial institutions to cut ties with the NRA that's important here. There, the Department of Health very specifically released or seemed to threaten banks to cut with legal action if they didn't cut ties with the NRA. And the court said, hey, if that's true, that's a First Amendment problem. But in the case of online disinformation and efforts by the Trump administration and the Biden administration to encourage social media companies to moderate COVID-19 related disinformation, it's less clear that there are threats of direct legal action. And so what I expect the court eventually to do is to say that there's a line between coercion and persuasion, and we don't see evidence that it's been crossed here.
Evan Bernick, thank you. We still are threatening you with the idea that we're just going to show up in class in the fall, but thank you for the help as always.
I welcome it. It's not a threat to me.
All right, you're a good man.
But it's glad to be back.
You're a good man.
Good one.
NIU College of Law, obviously reporting there live from the track at Indy. Mm-hmm. You could hear the cars
No.
doing it while he was driving.